Okay, so last class we discussed about patent prosecution, like pre-grant prosecution, post-grant prosecution. Okay, just like say working of patent, patent of additions, revocations, so all those things about the post-grant prosecutions of patent, post-grant prosecution of the patents. Okay, now I suggested when I was discussing the say content of any form of IP, there are three elements, just like creation of rights, transaction or transfer of right, and enforcement of rights. So how can you enforce your rights? You have a rights. If you don't able to enforce your rights, then there is no value of your rights. Okay, so enforcement of rights is coming by virtue of let's say we can consider the patent infringement. Okay, so before starting that the word infringement, some I call infringement is some infringer is called abductor, kidnapper, just English dictionary meanings if you follows. So before that, if you have to ask, so infringement is let's say just like say use of violation of rights. Violation of rights, let's say consider like this, violation of rights. So violation of your, I will again little bit more precise way, violation of your statutory rights. Statutory rights means the by virtue of law, some rights you have you acquired. Now the violation of that rights is called infringement. Okay, then before that you should know what you should know about or you should aware about what rights you have. Okay, that rights is within that boundary. So somebody is here, so he is not an infringer. Somebody here, so he is the infringer. So you should know what is the domain of your rights. So in that Patent Act, that statutorily the right, I already referred, patent right has been casted or drafted in a negative right format. So patentee can exclude others to use his patented product or the process product using that process. So let's see what way the say patent law has given right to the patentee. So what way section 48 of the Patent Act in the Indian context we are telling, they are telling that in respect of product patent, the patentee has the exclusive right to prevent third party, where third party means let's say maybe they want to consider third party means that unauthorized users, that let's say that if licensee can is considered authorized user, then who is not licensee may be considered third party. Again, government have some sorts of privilege. So government, some cases government can acquire the right of the patentee. So considering that, they are mentioning the third party. Third party means unauthorized user. So who is not a licensee. Okay. So they kept the provision of cross licensing. Okay. So in respect of product patent, the patentee means the patentee I already referred, whose name is reflected in the register as the owner is the patentee, exclusive right to prevent the third party making that product, using that product, offering for sale that product, selling that product, importing the purpose for making that product, importing for the purpose of using that product, importing for purpose of offering for sale that product, importing for the purpose of selling that product. So if somebody patentee has a product invention, let's say he has an invention called active pharmaceutical, has an invention or active pharmaceutical ingredient, or he has an invention for let's say a chemical, or he has an invention for a drug, or he has an invention for let's say a product means also can be device or medical diagnostic kits. So he can make say that third party, so exclusive right to prevent, he can prevent third party for making that product. So he can prevent any third party to produce that API, produce that the patentee who has the diagnostic kit, produce that, making that product. Using that product means they are also using, means he cannot third party cannot use that product. They are also, later on I will say that commercial use. Okay. The exception have been provided for research purposes use. If somebody used for research purposes, maybe he will not be liable for infringement. Offering for sale, he advertise that thing. Offering for sale, he advertise that product in a website. E-commerce people, let's say they are offering for sale. Let's say if e-commerce site, they are putting that API in their website. So they are offering for sale that product. Selling that product, e-commerce site, they are selling that product. Let's say Flipkart, they are offering for selling that product without permission of the patent. Importing the product for making that product, importing for research purpose may not be liable. Importing for making that product, importing for using that product, commercial using of the product, importing for that, importing for purpose of selling that product, all will be prevented without authorization of the patent owner. Similarly, for the process, in respect of process, the patentee has the exclusive right to prevent the third party from act of using that product process. What way that process can be used for benefit of the product or for the making of that product, act of using the product obtained directly by that process. So that API, for that production of that API, he is using that process. So he will be prevented to use that API also. Who that API which is ultimately produced by that process. So you understand the process is per se intangible. So the process is tangibilized in the form of a product. So how will you process part tangibilized in the form of a product? So they are telling, okay, he cannot use that product. That product is made by using that process. Act of offering for sale that product, he cannot on that product which have been produced or used by that process. Act of selling this, similarly importing that product. So see that using that process, then using that process for the product, other part they are tangibilized with reference to the product, just like a product right with reference to product have been provided. So now you got an idea about the the rights of the patentee. What is the scope and ambit of the rights? Rights means again I am repeating, rights means he can prevent other to make or use, import. Okay. So like this, so if let us say prevent others to make, use, import, where in the territory where he has the right, in the territory, T-O-R-O-Y, let us say territory means let us say India. Prevent other to make, use, import the product, or in respect of process, the use of the process or use of the product made by that process. Okay. So you got the rights. Now you got the idea of the infringement, means somebody violate the rights of the patentee, who then he will be treated as an infringer. Okay. So now the make, use, import may happen different way, direct, indirect, knowingly, unknowingly. So based on that, now say literally or scientifically they have defined the infringement in different ways, just like say direct infringement. So means you are directly infringing, means you are directly making the product that is covered by means of some patent. Again example, let us say a drug for cancer, let us say Novartis drug. Novartis has a drug patent in India and they are maintaining that patents, means they have a valid right in India. Now another company, company A, has started a manufacturing unit of that product. Okay. So they will be treated as a direct infringers. Why? They are directly producing that patented drug without authorization of the patentee. What the thing? Direct infringer or direct, the process will be treated as a direct infringement. Now indirect infringement, how? Let us say situation may arise is the product of the Novartis for making that product, what is happening? They require some sorts of ingredient, they require some sorts of equipment, they require some sorts of devices. Okay. So, maybe they are not directly say producing that product, but they are indirectly helping the direct infringer to produce that product. Okay. In that situation, they may be liable, depending upon the situation to situation, they may be liable for indirect infringement. Okay. So, they are say I can link their contribution with reference to that infringement action. So, indirectly they are also getting benefited from the direct infringement action of the infringer. So, I can put them on the boat of direct indirect infringers. Okay. So, sometime we call inducing infringement. Inducement or inducing infringement is coming within the purview of indirect infringement. Okay. Selling of ingredient, selling of equipment used for direct infringement, we are putting them as a indirect infringement. Similarly, they have willful infringement, unwilling infringement. Somebody knowingly that okay, this what is a valid patent, a company has started the manufacturing unit. So, intention is willful intention. So, willingly they are infringing. So, they are treated within the purview of some case, some jurisdiction in the purview of criminal law. So, they are willingly infringing. They know that there is a patent, till they are infringing. So, that is willful infringement. Unwilling infringement, they are ignorant about a patent, ignorant about the infringement, what is infringement kinds of situation. So, they are treated as unwilling infringer. So, that now these are the basics part with reference to the infringement, the different types of infringement. So, why I am telling all those kinds of situations? So, how you may be say just like when you are working in an organization, when you are just like say maybe purchasing some product or different things. So, how you may come within the purview of any of those set or subset that to make you aware of those situations, I am stating all those types of infringement also. Now, with reference to the patent and maybe with reference to the copyright later on, but for a patent specifically, we consider infringement may happen by means of literal infringement or infringement by means of doctrine of equivalence or purposive construction of claim. I referred already purposive construction of claim in respect of patent drafting. Doctrine of equivalence also I have explained, just like say something substantially doing the same function, just like say let us say joining means you are mentioning. A joining means maybe joining can be done by bolt, nut or welding, brazing, soldering. If you are somebody have a patent on say brazing and somebody is replacing that brazing by soldering and performing the same function, then not able to give some efficacy in respect of functionality, then he can be come within the purview of doctrine of equivalence. So, let us say somebody have patent on a joining means, and a joining means he referred specifically for a brazing joint. Now, somebody have created a soldering joint and also replacing that, just replacing that brazing joint, but that brazing joint and soldering joint is performing substantially the same function. They are used whatever way the brazing joint was used, same cases the soldering joint is also used. So, then that second case, even he has created a soldering different new process, even he then in that situation also he may be liable for infringement under the doctrine of equivalence. Equivalency will be just a substantially same function, based on substantially same equivalence, substantially same function. In Indian context, sometimes we call purposive construction. The same purpose, if he that same purpose, just like equivalency, we are telling same purpose if that infringer product and the patentee's product is performing the same purpose, just equivalency, then maybe you also treated in the purview of purposive construction of the claim, within the purview of purposive construction of claim, and based on the prior claiming part, he will be liable under the patent infringement. So, what are the different ways the patent infringement can happen? Let us say literal infringement or infringement by means of purposive construction, or in an US context we call it DOE, means equivalency or purposefully, though purpose of the infringer product or purpose of the patentee's product is equivalence or substantially similar. So, so it is wider ambit, although there is a very difficult situation may arises to prove this kinds of situation, although it is easier to prove literal infringement. I will come regarding those things. Okay. Let us say very interesting situation, you know that TVS is Bajaj versus Bajaj. They were fighting with reference to the twin spark plug. Okay. Twin spark plug, I have given that drawing for that spark plug referentially. So, that there also, let us say twin spark plug TVS versus Bajaj, TVS was claiming that they were the inventors for spark plug, and then Bajaj was claiming that Bajaj has created a spark plug. So, then whether that both the spark plug having that on the grounds of equivalency, purposive means purpose, whether they are fulfilling the same purpose, whether the design and the components of the spark plug of the TVS and Bajaj are similar or not, whether it will come up by virtue of literal infringement or by virtue of purposive construction and doctrine equivalence. So, it was an issue before the court to address that infringement within the purview of literal and or purposive construction of claim or DOE kinds of situation. So, that say that is a spark plug, then you have to differentiate the patent claims of the TVS, then you have to nice way distinguish the Bajaj spark plug from the TVS spark plug. Component wise you have to distinguish as you are technologist or engineers. So, you have to nice way then say if you want to analyze the infringement, the recurrently lawyers will rely on you people, then you have to say put the two components side by side, then each component subdivided into different units, whatever the smallest unit you are able to create for a particular component. When I have discussed about the flue-gas conditioning system, you remember, divided into different components, then you analyzed the similarity between the twin spark plug. So, this is the scientific way of analyzing the infringement. As you are technologist, again I am repeating, you should become should be thorough about the technology, means the product, then what are the different components remains in that product and what are the component remains in the Bajaj product and TVS product, just like a single spark plug and twin spark plug differentiated, twin spark, let us say twin spark. Okay. Advantage of twin spark you understood, and twin spark somebody another company also can generate, but their thing if it is the same or equivalence to that other company's thing, there lies the infringement. Okay. So, it is clear, you are clear about that TVS versus Bajaj part. So, now I will analyze this is just like the various modes of infringement, inducing and procuring infringement, just like say sale of ingredient, okay, part of combination, okay, then say sale of part of patented machines, somebody is selling a part of patented machines, a patented machine. So, the different case laws are there, then just like say if merely sale of some of the other parts is separately claimed, if one of other patented it cannot be, just like the different case laws, you may get different views based on the different facts of the cases, where a claim is for a machines and apparatus to be worked in a particular manner described in a specification, the sale of the machine that is not an infringement, would not be worked except the claimed manner, then it may lead to the infringement. Different situation, claim of machine operating automatically, repairing, okay, there you have to remember repairing of the patented article, here the some exceptions also provided, When you want to repair some component and use a process patented by some patentee for repairing purposes, then also may lead to the infringement. But say if foreign vessels reached in India and for repairing, let us say aircraft reached in India, now aircraft you have to repair, and for repairing of that aircraft you have to use somebody's patent, you may not be liable for infringement. So just like say, so different types of case laws are there with reference to repairing. Repairing some cases may lead to the making of the patented article, so that lead to the infringement. Okay, so that you are getting the idea that what are the different way direct or indirect infringement may happen. As to sometimes that like say exception have been provided with reference to the different ways, that research exceptions sometimes we call it, to some cases that's like disclosure to a government, to send an embodiment of an invention to a government authority for approval for use, just like a you call clinical trial related issues or others. So that kinds of situation used for to instruct people, so experimental purpose use, those are the different situations are there also. So then another part you can mention here, just like how you can consider literal infringement and how you consider say non-literal infringement. Let us say a company A has product or say a patent product or a patent that let us say he claimed that we claim, say the patent claim suggested we claim we claim, let us say it is a yeah, we claim let us say a polymer okay, a polymer, and then subsequently referred polymer having a polymer having the let us say properties, defined property A, let us say X, Y, Z, defined property he claimed. So in this case, what are the defined components he is there? Let us say polymer A, and within that subset, let us say A, within that subset he has the property like X, Y, Z. Okay. So now if company B is also producing, let us say a polymer, now he is not telling for company B, let us say producing let us say a polymer, let us say Teflon, let us Teflon. So A within that Teflon having the property that is already claimed by company A, X, Y, Z. So let us say now as a technical students you can now consider that polymer and Teflon, whether Teflon is a polymer, yes or no. So definitely you are considering Teflon is also a polymer. So now literal means let us say what are the components of the components of company A and what are the components of company B. If you just consider that Teflon is also a polymer, is a say Teflon let us say polymer, within that subset Teflon is there. So it is you are falling within the area of the right of the patentee Teflon. So now now Teflon is having all the attributes, let us say X, Y, Z. Okay. So you may consider now that okay that whatever the product claimed by company A and whatever the product you are using or making, that is coming within the ambit of the company A's product patent, and almost let us say all the features of the company A's product is remains in your product. Okay. So this thing we may consider as a literal infringement. Okay. Literal infringement. Okay. Clear? that if literal means just like say you are literally replacing, just like that. So, all attributes of the company's A's product patent is remains with the company's B's product manufactured or let us say even manufactured or sell or import. If company B import this product, make this product, use this product, all will come within the purview of rights of the company A. So, these are called literal infringement. Now, the situation may I already referred the joining means or let us say other equivalency or purposive twins per plug situation may arises. Maybe all the components of company A, B, C, D, these are the components are present in company A's product and definitely patent claim of the company A having the features A, B, C, D. Now, company B's product having the features let us say A, B bar, C bar, D, and let us say they are functionally equivalent, functionally equivalent. Okay. So, literally B is not there, B is here converted into B word, C has converted into C word. So, this is not literal infringement, no literal infringement, but because of equivalency and function, so they may come within the purview of infringement under DOE or purposive construction. Okay. Even all the elements of the components patented by the patentee does not present in these cases because of equivalency or purposive situation, that may also be liable under the patent infringement. Okay. So, now you understood if you have got a job of let us say infringement analyst. So, how will you analyze the infringement? Okay. I will suggest distinguish the how you distinguish the patentee's product from the infringer product. How you distinguish? Just first subdivided the patented product or process into small units, whatever possible way you can divide the units, then compare. Okay. Whether A here A, whether A means by virtue of Teflon and polymers, or A is here A or B is here B bar, C bar, D bar, then the equivalency in their functionality you compare, then you will be able to proper way analyze the patent infringement. Okay. So, let us wind up now. Patent infringement means somebody say using the say violating the statutory right of the patentee with reference to the product or process. What are the defined way he can violate? Violate by virtue of let us say a literal way he can violate, or non-literal ways also he can violate. He can violate the rights of the patentees, just like say A, B, C, D, or equivalency. By virtue of that, he is infringing the rights of the patentee. Okay. So, and exception have been provided for the research purposes, or maybe research purposes, research exception have been provided. Somebody using the patented process or patented product for research purposes, he may not be liable for infringement. This exception have been provided called research exception in the Patent Act. If use of patented product or patented process for research purposes have been treated as not infringement. Okay. So, now this is the overall idea or overall things behind the patent. The Act has several procedures, you should further remember where to file the suit for infringement. General district court to try that suit will be the appropriate jurisdiction for the filing the suit. Then what are the remedies provided? The injunction, and damages is provided in the Indian Patent Act for the infringement. Other jurisdiction criminal remedy is also provided. So, just like what is infringement, what way infringement will proceed. So, you have to file the suit in the district court, then it will be further proceed, and you should know that also. Then say what are the say by infringement, what are the things, by what are the remedies will be provided to me. You may get injunction either in the form of temporary or permanent. You will get damages, damages. Those are the different way you can get the remedies. Okay. So, let us stop here.